So you're talking about every subject you had, what a great opportunities you have. And really on the subject at hand, Felix Frankfurter, it kind of started at a curiosity, didn't it, with on the Rosenberg case?
It did. You're totally right, Greg. And I think you're probably the only interviewer I've ever had who knew that in advance, right? So
I read the book.
yeah, you read the book. I know, but so I was working in the justice's papers from, the Flood book, Well-Paid Slave was the first time I had ever used the justice's papers, and Blackman's papers had just opened, and it really opened a whole new world to me. And David Garrow, who's one of the people who blurbs this book, really taught me how to use the justice's papers. And he has a photographic memory, by the way. He had been through all of Harry Blackman's papers when they first opened, and he said, you'll need to look at this box in this folder, and this box in this folder, and this box in this folder, and this box in this folder. And I didn't realize at the time how remarkable that kind of total recall was that he has. But in any event, I was using the justice papers on the law school teaching market. I'm really interested in William Rehnquist and William Rehnquist's relationship with Robert Jackson. Started reading in the Jackson papers about the Rosenberg case and decided to write an article about it from the perspective of what happened at the Supreme Court of the United States. And I think a defining event for me, and I don't know if I put this part in the book or not, but I was really disillusioned with the Supreme Court's decision in Bush versus Gore. That was a case for me that kind of shattered my image of the justices on kind of believing what they said in their opinions for a couple of reasons. One was, I went to law school in the late 90s, really at the height of the Rehnquist court's federalism revolution, right? Where they were really saying, hey, the federal government is one of limited enumerated powers, and we should leave everything else to the states. And when they decided Bush v. Gore and really stopped the state of Florida's recount and ignored the political question doctrine and really all these things about judicial restraint that they were kind of standing for at the time that they avoided it, it really hurt my image of the justices. And then I read Felix's opinion in the Rosenberg case, and when he wrote after the Rosenbergs had been executed, and he was really writing for his law clerks and his former students who were similarly disillusioned with the Supreme Court of the United States after the Rosenberg case. Phil Elman in particular, who was one of his law clerks, who was in the SG's office, as you know, for years and years, after clerking for Frankfurter, was totally disillusioned with the way the court had kind of declined repeatedly to hear the case of Julius and Ethel Rosenberg on the merits, and then in a kind of slapdash way considered one claim, days before the Rosenberg were executed about whether they or not they were executed under the wrong statute. And Frankfurter said a line in there. He said he published his dissent after the Rosenbergs had been executed, and he wrote, "History has its claims," right? And that really resonated with me. He was telling his law clerks, don't lose faith. And Justice Breyer was telling clerks at the court around the same time after Bush v. Gore, don't lose faith in the Supreme Court of the United States. Don't lose faith in the rule of law. Don't lose faith in the power of reason. And so those two things kind of matched up to me. And I was really kind of puzzled by the Rosenberg case. How could four of the most brilliant justices who've ever sat on the Supreme Court, I look at that court as kind of like or in a fantasy baseball kind of way. You let me pick Frankfurter, Jackson, Black, and Douglas. I'll give you any other four. I win every time, right? Just on like sheer candle power, right? And on those four guys. And I don't think four people have ever sat on the court together who were that smart. And for them to really foul it up that badly, and to have Justice Burton, and I'm a big Harold Burton fan from that article on the Rosenberg case, and from talking to E. Barrett Prettyman Jr. about the case, and from talking to E. Barrett Prettyman Jr. about Harold Burton, and from seeing Burton's letter, Prettyman's letter to Burton, that the law clerks voted Prettyman, the justice, they would hear their case that their lives were at stake. That Harold Burton was the one who was kind of a grown up in that case and was trying to do the right thing, and the others, you know, just couldn't get out of their own ways. And it was upsetting, and I think Justice Frankfurter and Justice Black more on the right side of the case for most of the case. I'd say, in terms of wanting to hear argument, we're most consistently in favor of hearing argument. I thought Justice Jackson highlighted the critical moment in the case, where a case of a claim of prosecutorial misconduct was raised to him, and he wanted to stay the executions and have argument about it, and then Justice Douglas objected it. And I just thought that what happened between Jackson and Douglas was really unfortunate, and was kind of an institutional failure. And what Justice Douglas did in particular really turned me off to him. That he didn't actually want to hear the case. He just wanted to be on the right side of history as dissenting in the Rosenberg case. But anyway, that was how I got interested in him.
And by the way, just for the camera, for those who may look at this, I'm going to read just a few sentences here just to get everybody's wrap their head around it. The case of atomic spies Julius and Ethel Rosenberg revealed Vincent's lack of leadership and Frankfurter's and Jackson's enmity towards Douglas. On March 25th, 1951, a jury convicted Julius and Ethel Rosenberg of conspiracy to commit espionage by passing atomic secrets to the Russians. Judge Irving Kaufman sentenced the Rosenbergs to death. That sets the framework for then the various stays. And frankly, you need a diagram, a Venn diagram to kind of follow it all.
Very complicated case. And I had done some capital defense work in college, in law school pro bono. And so I was interested in that whole habeas corpus process. It was very complicated. It took a lot of twists and turns. But ultimately, there was no real briefing on the merits of the claims, right? So there was, no granting of certiorari and no, there was just kind of an 11th hour hearing on whether or not the Rosenbergs had been tried and sentenced under the wrong law, right? The claim at the 11th hour was that they should have been tried under the Atomic Energy Act, and they were tried under the Espionage Act, and that the Espionage Act was the wrong law to try them under. And but I was really more interested, as I wrote in the law review article version, in the claims of prosecutorial misconduct, because there was evidence of prosecutorial misconduct. That said, we do know now from the Venona transcripts, the Soviet, the decoding of the Soviet files, that Julius Rosenberg was a spy for the Russians and was involved in a spy ring. Ethel, his wife, there's less evidence. There's evidence that she had knowledge of the spy ring, but whether she participated as a legal matter, I think is still kind of hotly contested. And the Justice Department officials, William P. Rogers, admitted that they were using Ethel as leverage to get Julius to confess and tell them what he knew, and that they did not think that she would go to the electric chair, with two young children, with two young boys, rather than get her husband to tell everyone what they knew and or at least confess. And she didn't, and he didn't, and they both were executed. But it was I think it showed the dysfunction of the Vincent court. We haven't talked about Fred Vinson yet, but he was the Chief Justice. He was holding ex parte conversations with the Justice Department about speeding up the execution in those final hours, which was a real no-no. And one of the things I did in that article, by the way, Greg, was there's an FBI document that claims that Jackson instigated that ex parte hearing, and my law review article sort of showed otherwise. And I even talked to one of the prosecutors when he was still alive, and I think it was like a game of telephone. Like someone told someone that Jackson was there and had organized it, and then when you get to the bottom of it, Jackson wasn't there, and it's unlikely that he organized it. So I felt like I did try to set history right there, but it's a complicated case. but it was fun, and it was a window into Frankfurter and really his whole world and his, relationships, his relationship with Jackson, his relationship with, the other justices, and even his relationship with William Rehnquist, which there isn't a lot in my book about it, but um, like a lot of really smart law clerks, Rehnquist was sort of dazzled by Frankfurter's charisma and kind of willingness to argue about anything under the sun, right? And I think a lot of law clerks left with that impression of him, right? As he was just such a live wire. Just to quote a line about one of our former presidents, he's somebody you'd want to have a beer with, right? Just because he's so much fun.
Since you brought it up, I wasn't going to bring it up, but you brought up Robert Jackson. Here we are at the Jackson Center, and the relationship that is throughout your book, Felix Frankfurter and Jackson. Can you start someplace? Is there a genesis where Jackson's orbit overlaps with Frankfurt? I mean, he was kind of a guy from Jamestown, New York, 1934. He ends up in Washington, ends up with the tax department, and then works its way around ultimately to Solicitor General, Attorney General. But do you know where that all kind of started?
Well, not exactly, and I'm going to defer to my friend John Barrett. I mean, I know. Look, I mean, the short answer is the New Deal, but let me just kind of point one thing out. I mean, the Jackson and Frankfurt are total outsiders, right? Jackson from Jamestown and Frankfurter as this guy who comes to the United States from Austria at age 11, not knowing a word of English or ever having heard one spoken. And by age 26, he's on a first name basis with former President Theodore Roosevelt. And, Jackson, same thing, right? He's nobody knows who he is in Washington when he comes and into the tax division. And his rise through the Justice Department is, unprecedented, all the way to the top of the department. So here you have two people who are kind of not overlooked isn't the right word, but just by sheer dint of intelligence, personality, and ability, right? Get to the top of their profession through different ways, right? Jackson largely through the Justice Department, and Frankfurter, of course, became a federal prosecutor shortly after graduating first in his class at Harvard Law School, and befriends not only Theodore Roosevelt, but Henry Stimson, who's the head federal prosecutor for the Southern District of New York. And then he goes to Washington with Stimson in the War Department. And, from there, it takes a longer time, but I think where they're united, right, is by Franklin Roosevelt, right? And it's as New Dealers in the early 1930s that Jackson and Frankfurter sort of join forces. Certainly by 35, Greg, when the court has the Supreme Court has struck down what historians would regard as the first New Deal, right, which is the centerpiece of which is the National Industrial Recovery Act and Inspector Poultry, and sort of this genesis of the second New Deal, right? One of the centerpieces of the second New Deal being the National Labor Relations Act, and Social Security, and et cetera. At that point in 35, Frankfurter's down in Washington that summer, every week for several days a week, staying at the White House. And we know that because the White House logs capture some of, but certainly not all of, Frankfurter's visits. And certainly by that point, by 35, Frankfurter and Jackson are kind of in the trenches doing two things, right? One is, how do we pass this new legislation? How do we write the new legislation so when it goes up to the Supreme Court the next time, it won't get struck down, right? Which is really what Frankfurter's working on with a lot of his young former students, like Charlie Wazansky and Tommy Corcoran and Ben Cohen, and there's some other names I'm going to leave out there, but he's really in the trenches with them. And then at the same time, Frankfurter's working with Sam Rayburn, John Nance Garner, and the old Southern bulls, in the Senate and in the House, to get the legislation passed, right? And then on the back side of it, you've got people like Jackson defending it, right? At the highest level, Frankfurter has really, the Justice Department was not a place where there were a lot of great lawyers under FDR in the first New Deal. There were a lot of patronage appointments in the Justice Department, and so there was a lot of turnover, right? And I think part of Jackson's rapid rise was he was so able, right? And there were so many people who weren't there because of their ability, that he was just able to shine, right? And I think Frankfurter helped Stanley Reed in particular stock his Solicitor General's office with kind of a who's who of Harvard law graduates, Wazansky, Paul Freund, and a bunch of others. That he made sure that when they defended the second New Deal, that there were people in Reed's Solicitor General's office and people like Robert Jackson who were doing the advocacy, so that the administration could put their best foot forward.
Curious, 1937 was the announcement regarding the court packing, and took a lot of people by surprise, including Jackson and including Frankfurter. Yet ultimately, Jackson had to carry the bag for Roosevelt in Congress. And as I read, that Frankfurter was privately opposed to the court packing, but he became silent on the subject. Did you find in your research Jackson and kind of Frankfurter's? There was a delicate balance for Frankfurter, certainly.
Yeah, so I think Frankfurter's opinion about court packing is really tricky, and I'm not, I think there's some nuance there, and I'm not sure, and the sources are not great on exactly. I think Frankfurter thought that the court deserved it, that there was a problem with the Supreme Court of the United States about the way it was acting. The justices were imposing their personal views about the New Deal and about the size of the federal government, and about Roosevelt himself, and they were reading them into the Constitution. So I think Frankfurter was all on board attacking that Supreme Court. And what he was doing was, Roosevelt did not tell him in advance. He said, there's going to be a surprise, just withhold judgment. You're in for a shock. Frankfurter was totally shocked. He, like Jackson, was left in the dark, right, on court packing. But I think where Frankfurter was super comfortable was helping Roosevelt with building a case against the Supreme Court, right? That he was not, so in a lot of ways, he was not conflicted at all about the scope of the problem, right? So he said, we've got a problem. I think where he disagreed with Roosevelt was on the remedy, right? And I don't think if he had been asked ex ante by Roosevelt, should I propose a bill to increase the number of justices up to a maximum of 6, I don't think Frankfurter would have said yes, and he certainly wouldn't have told Roosevelt to have some BS rationale, right? That like the justices were behind on their work, right? Which was the original rationale cooked up by Homer Cummings and his folks, and Jackson, of course, moved away from that rationale quite quickly. In defending the bill before the court, before Congress. But I think he was less comfortable with the remedy, but he saw the problem, right? So and I think what Roosevelt asked him to do was, look, just don't come out publicly and oppose the plan, right? And I think that cost Felix with some of his really long time friends, C.C. Burlingham, for one, another one of his classmates, I'll get it, Grenville Clark's the other, right, were really pushing him hard and said, you've got to come out and say something. And Frankfurter said something really interesting back to Grenville Clark. He said, hey, look, I'm the Jew, right? I'm the red, right? Like they already think I'm this like Jewish communist controlling the New Deal. right? I mean, they called it the Jew deal, right? Because they thought that Frankfurt and other Jews had complete control of Franklin Roosevelt. He said he did not want to become the focal point for or against court packing, and so he stayed aside. Alex Bickle, who I really have huge admiration for, he's a professor at Yale Law School, and he was Frankfurt's law clerk as you know, during the 1952 term, during that first term when they argued Brown versus Board of Education, and one of the most brilliant constitutional theorists of all time. He thought that Frankfurter stayed silent mostly out of loyalty to Roosevelt. And in the same way that I think Jackson went to Congress and testified for the bill out of loyalty to Roosevelt, right? So I mean, that's where you've got this bond between them, right? They think Franklin Roosevelt, at least I know Frankfurter did. Maybe Jackson's more mixed on Abraham Lincoln, but Frankfurter realizes early, before everybody else, that Franklin Roosevelt has the capability to be the greatest president since Abraham Lincoln, right? And he was going to help him any way he could, achieve that. And I think Robert Jackson certainly had an enormous admiration for Franklin Roosevelt, as John Barrett has shown us in That Man. It was an enormously close relationship there, and in some ways, Jackson and Roosevelt had a little more in common in terms of where they were from. Both being from they weren't from Hyde Park and Jamestown. Growing up in a little more small town New York environment, certainly not in the same economic class, but they were united in their love and admiration for Roosevelt. They certainly had disagreements, right? There were points, of real disagreement. But Frankfurter, I know, would not be on the Supreme Court in the United States without the admiration, support, and lobbying of Robert Jackson, right? One of the myths, and really the first chapter I wrote in that book, was trying to destroy the myth that Frankfurter knew from the moment that Cardozo died that he was going to be on the Supreme Court and be Cardozo's replacement, that it was like a done deal from the beginning. It was a hard-fought political fight from the old guard Democrats, right? James Farley and the Attorney General, who I just mentioned. Now I've lost it.
Homer Cummings?
Yeah, Homer Cummings were totally opposed, right? They kept saying geographic diversity, right? They're like, we need people not from New York, not from the East Coast on the Supreme Court of the United States. We need a Westerner, preferably a Catholic Westerner, right? This was what they were doing. And you had the Young Turks in the New Deal, right? Tom Corcoran, Ben Cohen, Robert Jackson, saying we need Felix Frankfurter. Forget this nonsense about we need a Westerner. And then you had really perceptive people like Wiley Rutledge, who of course eventually goes on the Supreme Court and was one of those Westerners who was in the running for the seat, who said, when Homer Cummings and Jim Farley talk geography, I can't help but think there's just a bit of anti-Semitism in all that geographic diversity talk. I thought that was really perceptive of somebody to say. And also Rutledge kind of took himself out of the running and said, Felix deserves this seat. And what does that say about Wiley Rutledge of a human being? There are not too many people who aspire to be on the Supreme Court of the United States say, oh no, I think somebody else should get to go first, right? It was remarkable, but Roosevelt's 11th hour, and Roosevelt felt a little hamstrung because apparently, I don't have a lot of evidence of this, but apparently he promised during the court packing fight that he would, in expanding the court, also diversify where the justices came from. So he had promised some geographic diversity, and it was Jackson who went to him really late in the day and said, look, I as SG need Felix Frankfurter on the Supreme Court. I need a justice who's going to understand my arguments, who's going to get it, and who's going to stand up to Charles Evans Hughes, the Chief Justice, in conference, which is hilarious because, of course, Frankfurter and Hughes become very close. But I'd say the people two most responsible for Frankfurter's nomination, besides Roosevelt himself, are Robert Jackson, and then Harlan Fiske Stone met with
Mhm.
Roosevelt late, right after Jackson did, and basically said, there aren't enough qualified people in all the other circuits for you to name one person from every circuit. Just put Felix Frankfurter on the Supreme Court. And so that they really get the credit. And, I don't know if Felix knew it. I don't know if he even knew it, that he owes Jackson and Stone his place on the court.
So Frankfurter becomes a member of the court, 1939.
Yes.
Yep. And one of the things I found fascinating in your book, and it's perhaps somewhat of a criticism of Frankfurter during the time period, that he was a terrific social animal. He loved to wine, dine, meet people, have them at the house, go have dinner with them. And that's all pre-court, but he sort of continued that aspect post-court. And sometimes there's a fine line where all of a sudden, as justice, you probably shouldn't be over in that territory.
Yeah, I'm not going to defend it because I think your assessment's right on. I just want to kind of put it in perspective for people. If Felix Frankfurter were alive today, he'd have 300,000 Twitter followers. He'd be on Instagram, and he'd be the king of appellate Twitter, as they say, and legal social media, right? He'd have a podcast, right? And but in those days, Greg, the way you influence people were by writing 10 to 15 letters a day, which he did, and collecting friends like baseball cards, right? And he collected friends like baseball cards, and he was invested in those friendships, and he was a total extrovert. And he did not turn off that kind of letter writing, seeing people. When he joined the court, he didn't turn that off, and Stone was privately critical of that. Stone told C.C. Burlingham, "You got to talk to him." And I think once the war started, it got worse, right? Because Felix now thought, well, now I have a purpose, right? Now I have to, and he saw the war coming, right? He knew the war was coming long before other people did, because people were writing him from Austria. I mean, in the mid 30s about what was happening. He had, a year before the court, he had saved his dear uncle. He had saved his dear uncle Solomon from a Nazi prison, with some work with both Lady Astor, but also with people he knew in the State Department. So he knew this was coming, and at that point, he was doing a lot of advising in the Roosevelt War Department, and he had helped get Henry Stimson reinstalled as Secretary of War, because he knew the war was coming, and he was engaged in way too much politicking, way too much policy making behind the scenes, and not enough time writing opinions, drafting his own opinions, and going through many drafts of his opinions. Even before the war, he was dictating opinions, or he would stand over his law clerk's shoulder, and that law clerk would type, and Felix would talk. And that wasn't really a way to write great opinions. And the way to write great opinions, and I'm not just saying this because it's you and it's the Jackson Center, but the justice that is really, to me, the gold standard on how to write a judicial opinion is Louis Brandeis. Brandeis would go through draft after draft after draft, right? Handwritten draft, handwritten draft, handwritten draft. Then he would send it to the printer and go through a zillion other drafts. And you know who else adopted that strategy? Robert Jackson,
Yeah.
right? That's Jackson's method. And my one huge criticism of Frankfurter was that he needed to be a little more like Jackson in terms of opinion writing method, and a little less of a policymaker. My only thing I'd like to say for the record is there is a long history at this point in time of justices engaged in extrajudicial political activity while on the court. Frankfurter's own mentor, Louis Brandeis, was advising Woodrow Wilson while on the bench, right? He was writing speeches for Woodrow Wilson while on the bench. So, and look, this goes to like William Howard Taft was picking, Harding's Supreme Court nominees for him, right? So this kind of violation of separation of powers, which today would be unheard of, right? You had even other members of his own court, right? Former New Dealers who were advising Roosevelt as well. I'm not saying it's right. I'm just saying that it was way more common then, right? If one of the justices today were discovered to be advising President Biden, there would be outrage and calls for impeachment. And then Washington was just a different place. But I do think that Frankfurter took it to an extreme, and it had a detrimental effect on the quality of his opinions.
Was that contemporary? Was there a sense during the time period where somebody said, gee, Felix is a great arguer, he's got a great oral argument, he has a presence, he can persuade people, but he can't write?
Well, I think he can write. I don't think he was. You know why I think he can write? Because his New Republic editorials in the 20s were unbelievable, right? And I think he wrote those. And he was the foremost critic of a very conservative Supreme Court in the 20s. And they were very well written. I just think he got out of practice. I think he got into bad habits. Even going back to when he was at Harvard Law School, I think he was having a lot of very smart law students co-author his written work. And I think he got out of the habit of writing his own stuff, and that really didn't stop I'm not saying he never wrote an opinion. I'm just saying he didn't write all of his own opinions, and he didn't go through the kind of drafting process on all of his opinions the way Jackson did. There were times when Frankfurter went through a zillion drafts, but his opinion writing process looks a little more like it does today, right? Where a law clerk might like Frankfurter might dictate some thoughts. The law clerk might write a first draft, and then Frankfurter would heavily edit it repeatedly, right? That's the kind of common practice now, right? But back then, the way to write a great opinion was for the justice, whether it was Robert Jackson, William O. Douglas, or Hugo Black, was to write it yourself and to go through a lot of drafts. And I didn't see Felix doing that. And there was one other thing you asked me about that, whether he was a great writer. I can't remember. It was a really good question, though. We'll get to it, I'm sure. If there's something I missed, let me know.
Well, talking about opinions, the case where Frankfurter and Jackson came down on different sides was the Barnett case, West Virginia versus Barnett. And I know those who we've had the Gobitis. We've actually interviewed her, Lillian Gobitis. Sidebar: Phil Donahue and I went down and interviewed her a few years ago, and then subsequently had the Barnett sisters here. So we've had ample opportunity to talk about that case. But we know Frankfurter where he stood on the Gobitis case, and of course he was all of a sudden found himself in the dissent of the Barnett case, which is what we use and hold as a gold standard here at the Jackson Center.
Yeah, look, that's one of Jackson's great opinions, and I think Frankfurter got himself on the wrong side of being the liberal leader of the court in those cases. I used all the material that you assembled with the Gobitis, with the Gobitises, and with in the other case in West Virginia with the Barnett sisters. So I appreciated that. All the work that you did on that. I think Frankfurter really the issues changed for Frankfurter when he got on the court, right? It was no longer, can the Roosevelt administration do this, right? Is this within the scope of the federal government's power, right? Those issues were largely decided. Still you had the case involving wheat, the Jackson Road, and in 43, but most of that all got decided really in 37, right? And Wickard versus Filburn, I know comes a little later, but the issue was really, when does the Supreme Court started using the First Amendment to strike down state laws in ways that it never really had before, right? This process of incorporation, in which the First Amendment started to apply to the states, first free speech and free press, but then free exercise, the free exercise clause and the Establishment Clause, this was all new, and I think Frankfurter was really he and Jackson had some similar instincts, which was that a limited role for the judiciary, that was their takeaway from the New Deal constitutional crisis and the court packing fight. And Frankfurter was really guided by precedent, right? And I think he was really driven in those cases, above all else, by, hey, 5 courts had looked at this flag salute issue before Minersville versus Gobitis, and they either said this raised no federal constitutional claim, or they declined to take the case for whatever reason, or they just affirmed, without even an opinion. This is just at conference. And he's like, I'm not going to start to, ramp up the court's power and kind of make the court this kind of censor of the public school system. And he certainly wasn't in favor of a flag salute, right? But he saw public schools as a great democratizing institution, one that changed his life, right? PS 25 in New York City. I mean, I write about his teacher, Miss Hogan, threatening, his classmates with corporal punishment if they spoke to him in German. So I mean, the public schools are so foundational for him, and I think he saw this as, hey, should we be using, free exercise or free speech, as a way to take away, the state's ability to write a public school curriculum or to teach evolution. So I think although I have huge admiration for Justice Jackson's opinion in West Virginia versus Barnett, and a lot of people told Frankfurter to take out the first paragraph of his dissent, where he says, as one of the most despised, minorities in history, right? I'm certainly sensitive to injustice, but I think, and a lot of my colleagues have said so too, I think people's views have kind of changed, at least about, I think, where Frankfurter for a long time looked like he was on the total wrong side of history, and Jackson's opinion, and I'm not denigrating Jackson's opinion when I'm saying this, I just think it looks like a closer case today, when you have justices on the current Supreme Court of the United States talking about the weaponization of the First Amendment to strike down laws of general applicability, and the way they weaponize the First Amendment is Jackson's decision in West Virginia versus Barnett. And so I think a funny thing has happened, right, where people who oppose this idea of judicial supremacy, and as I know, Greg, right, Jackson's book's called The Struggle Against Judicial Supremacy, right? He's out front. He and Frankfurter both oppose judicial supremacy. There's a weird irony that Jackson's opinion is now being used by judicial supremacists to kind of use the First Amendment as kind of a censor on laws of general applicability. And Frankfurter, if I could go back in time, I would say, hey, why not write a narrow opinion, Frankfurter and Jackson, and say, hey, West Virginia, hey, Minersville, you need to accommodate the religious beliefs of these school children, but without sounding like we, the Supreme Court of the United States, are bringing the 10 Commandments down from Mount Sinai, and we get to have the last word on this stuff. I think, that's kind of where I am on it. And I can see Frankfurter's perspective, but his role was not really the same on the court after that, right? Douglas and Hugo Black really took over the leadership of the kind of liberal wing of the court, and Frankfurter saw himself in opposition to them because he saw themselves as kind of aggrandizing the Supreme Court's power. And in kind of a funny thing, Greg, even though Jackson wrote Barnett, and it's a beautiful opinion, one of the most beautiful opinions we have in the United States reports, Jackson and Frankfurter were on the same side in most of those battles when it came to expanding the Supreme Court's power.
Your book talks an awful lot about Frankfurter's feelings towards judicial restraint. The idea of stare decisis is, in fact, an important concept, really, except for civil liberties, civil rights, and that's part of the tenor when you even segue into the cases, the segregation cases, which ultimately lead to Brown. Can you talk a little bit about that?
Yeah, I mean, I think, look, Frankfurter's mentors are Oliver Wendell Holmes Jr. and Louis Brandeis, right? And the the article for him that's kind of the fundamental article is James Bradley Thayer's 1893 Harvard Law Review article. That's really about this idea that Supreme Court justices shouldn't overrule a federal law unless it's unconstitutional beyond a reasonable doubt, almost like a criminal jury kind of standard. But the problem with Brandeis and Holmes is they weren't real good when it came to protecting the rights of African Americans and enforcing the 14th Amendment to promote the idea of equal citizenship. And they were either silent or voted the wrong way on a lot of cases involving African Americans. You know, I think Frankfurter realized that that had been a blind spot of both of his mentors, and Frankfurter, of course, being on the National Legal Committee of the NAACP when he was a lawyer, you know, a law professor, and advising Walter White through some of those early battles in the 1930s, having his former student be the first Black editor of the Harvard Law Review, Charles Hamilton Houston, and Houston then became the first special counsel for the NAACP, sort of running its legal shop. Frankfurter saw that things were going to change. And then also you've got Frankfurter hiring the first Black law clerk on the Supreme Court of the United States, William T. Coleman. I used your interview, Greg, with William T. Coleman in my book. There's a line in the book that's straight out of your interview with him, where he saw tears in Justice Frankfurter's eyes when he was not able to go to the Mayflower Hotel to eat with the other law clerks. When Frankfurter heard that, and of course, as you know, Greg, Coleman's law clerk was Elliot Richardson, and Elliot Richardson said, "Hey, Bill, I got too much work to go to the Mayflower. Let's go to Union Station to eat," which was the only place in Washington, D.C. at the lunch counter in Union Station in those days in 1949, where a Black person could eat with a white person. One of the only places. So, you know, those things leave a mark, right? And Frankfurter, coming from nothing, right, coming from Austria and fighting a lot of anti-Semitism, I think saw the freedom struggle and the Black struggle for equal citizenship as something that you know, he was fighting against the odds. William T. Coleman was fighting, you know, a lot, you know, overcame a lot of barriers, as did Charlie Houston to do the things that they did. And Houston, of course, was the architect of the NAACP's separate but equal strategy, which was attacking the equal portion of separate but equal. Another Frankfurter student actually wrote the memo. He was Houston's fellow law review editor on the Harvard Law Review. I'll get his name in a second. It's just escaping me. But you know, I think Frankfurter was sympathetic, and what I write in the book, this is a long way of saying that Frankfurter really adapted judicial restraint to realize, like, yes, we need judicial restraint, but we also need to enforce the promise of the 14th Amendment, that everyone in a post-Dred Scott universe is equal citizens, are equal citizens. And I think he was pretty consistent about that. Now, he might have been a little more incrementalist about it, right? He was, I think, as I say throughout the book, if you look at his opinions on race and his votes on race in the 40s, you know, even in the early 40s, he's taking a kind of step by step approach, and he's cautious about the way he wants to do it, and he's not going to start overruling precedents left and right. But you know, he gets to the right place, but not really by taking giant steps, but by taking small ones.
And as we kind of talk a little bit about Brown versus Board 1, and I know your book concedes, of course, Warren writes the unanimous opinion, but behind the scenes, not given as much credit as he should, is Frankfurter's machinations, I should say. I don't know, maybe that's the correct terminology.
No, it's the totally right word. You know what, Greg, what I think happened was Richard Kluger, who wrote the fantastic book, Simple Justice, which will never be equaled by anyone, about Brown, talked to Alex Bickle and talked to Phil Ellman, Frankfurter's clerks, and got this kind of Frankfurtian point of view. And I think that was kind of the high water mark of Frankfurter getting credit in Brown. And then there was a reaction to that book by kind of the Earl Warren partisans and people who thought that that was a little overbaked. And then the revisionists, led by some very fine historians, kind of discredited what Frankfurter had done. And then this kind of great man theory kind of emerged about Earl Warren, that and what I reject in the book is this idea that Warren, comes onto the scene. Fred Vinson dies of a heart attack after the first oral argument in Brown versus Board of Education. And by dint of his personality, charm, and political skill, Warren magically finds 9 votes on a very divided court after cases like the Rosenberg case, and unites everyone. And I just think that is really too simplistic, right? That, all of the things could be true, right? That yes, Warren got some credit for being new and for his political skill, but he was a recess appointment by President Eisenhower. He wasn't confirmed until February. Until his confirmation, he did not start writing or even thinking about how to write a draft opinion. And all this stuff had happened before that time, right? Including Frankfurter pleading with the court to re-argue it under Fred Vinson, and having his law clerk Alex Pickle write a memo about the history of the 14th Amendment with regard to segregated education. And then in a part where I think I bring something new to the story, Earl Warren's calendars record which justices were seeing him during that critical February to April period in 1954. And Frankfurter saw him, I think it was, I've got the exact number in the book, but no one saw Warren as much during that period as Frankfurter did. And then the second most was Hugo Black. And that sort of makes perfect sense to me, right? They're 2 of the strongest voices in that room. And I think Hugo and Frankfurter deserve enormous amount of credit for helping Earl Warren reach what was just a huge moral triumph for the Supreme Court of the United States. And of course, Robert Jackson would have been right there with him. He's got a long-standing prior relationship with Warren, right? They belong to the same, club out in California together, but he's in the hospital, right, with a heart attack, and at Doctor's Hospital in Washington, and he's convalescing. So, Jackson's out of pocket, on this one. And so, Frankfurter and Black, I really think help Warren get a unanimous court. And just this idea that either Frankfurter or Jackson were going to be in dissent in Brown versus Board of Education, I just find totally ridiculous. Just absolutely ridiculous. And I was fighting some of that in the book too. Like, look at this memo. Look at this memo. Look at this conference vote. Look at this conference vote. And I think over time, some of these things get kind of distorted. And some of these documents, especially conference notes, it's not always objective on what they say. Some of the reading is in the eye of the beholder, and Douglas's conference notes look a little different than the other justices' conference notes, and you've got to read them through the lens of, this is somebody who just went to war with Jackson and Frankfurter over the Rosenberg case. They hate each other, and Douglas's conference notes don't make Frankfurter look real good, right? And they're a little bit of an outlier compared to the other justices' notes, but it was a really fun chapter to write. As I said, I think it was a triumph for the court, and it was a triumph for Frankfurter, and it was a triumph for Robert Jackson, because it was a hard case for them, right? I think it was the outcome was easy, but as I tell my law students all the time, the reasoning for them was hard. What do we want to say? And I challenge my students, well, what should Brown versus Board of Education have said? And then that's a harder interpretive question. And I don't love the method they chose, but hindsight's 20/20, and it was hard, and 1954 to get a unanimous court and to write something that everybody could agree on. And I good on them for getting there.
Well, one of the things we spent a lot of time on, because Barrett Prettyman Jr. was on our board. In fact, he spoke at length about the concurring opinion of that, and was fascinating just to get his backstory, of which you capture here.
Yeah, and of course,
Kind of
John
just
Barrett.
waiting.
Yeah, John Barrett and I have we knew Barrett too, and we interviewed Barrett, and we wrote a law review article together. And John, of course, being the foremost expert on Justice Jackson I know of in the country, and yeah, I mean, there are points where we disagree with Barrett Prettyman Jr., whom we loved, right? Both of us. It was just such a great person and great American, and there are points where we disagree. One thing I just wanted to point out, I pointed this out to John. Jackson never labels his own opinion a concurring opinion.
Right.
If you look at the document, right, it's just a memorandum, right? And I write in the book, right? This is how Jackson thinks his way through cases, right? Is writing, through writing, and it's a kind of a pattern, right? Well, like, how do I get to the right interpretive analysis? Well, I got to write my way through it. Like, will this write? But this idea of like people characterizing it as like a possible dissent, like, do you see the word dissent in there? Right. And then, and this idea that he would have published, I'm not sure he would have. I mean, who knows what he would have done with it? We don't know. Like, who knows if he hadn't had his heart attack, what would have happened? But I just think this is the way he thinks through problems, is by going through these drafts and writing things up. And I think he was just trying to kind of clarify his own mind. I do want to say this for the record. What Barrett Prettyman did with Robert Jackson is just simply amazing, right? To write the justice a memo and saying, you shouldn't start with your doubts and fears, but
Right.
you should start with your reasons for ruling in favor of these courageous Black school children and their families. You should start with why the 14th Amendment says that separate but equal education is unconstitutional. What a remarkable thing for someone, a law clerk, to write a justice. You've got to have a really close relationship with that person to be able to say to them, hey, Justice Jackson, don't start with your doubts and fears. Like, I clerked on the Ninth Circuit Court of Appeals, and I can't imagine, and my judge and I have a very close relationship. I can't imagine saying that to her, right? Like, I can't imagine, much less writing it down, right? And it just took a lot of courage, and it's a remarkable document. And the only other more remarkable document is where Barrett Prettyman refutes William Rehnquist's ideas that Jackson wanted to dissent in Brown versus Board of Education. So
Yeah, just as an aside, on that subject, because I know you and John wrote about it, and we won't go into any more detail other than Barrett Prettyman was coming up to Chautauqua for an event, and I was going to interview him just as part of a legacy history, because he's history. He goes,
yes,
I want to speak first. I want 15 minutes to present. And John and I are in the audience, and I'm ultimately going to get up and then do the interview. And all of a sudden, he laid out this bomb. And I was looking at John, whoa, because he had to get it out. He had just had to get it out. Well, that ultimately, led to what you guys did, much greater research.
yeah, and of course I think we disagreed with some of his characterizations, and but I think he was on the right track. There's no way Jackson or Frankfurter were going to dissent in Brown. I mean, that just strikes me as preposterous. But if you think about their judicial philosophy as both believing in judicial restraint, as both not wanting to aggrandize the power of the Supreme Court, they realize this is a moment, right, where the court's role is going to change forever. And how do you do this, right? And so, I think they saw the gravity of it, and they were cautious, and I think that caution was justified, right? I think the caution reinforces why they were both great justices, right? They realized that, like, hey, we can't become the national school board for the United States of America, right? We, the Supreme Court. Can I just say one more thing about Jackson, Frankfurter, and Brown? Because there are things that are, I think, not buried in the book and that are real subtle, but that I found fascinating about the oral argument that I don't think a lot of people have picked up on. The best colloquy in Briggs versus Elliott, which is a South Carolina case, and the only time that John W. Davis gets any hard questions are from both Jackson and Frankfurter. And the question, which starts with Jackson, is as follows. And it's, can Congress use its Section 5 power to overturn racially segregated schools, right? And that's one of these 5 or 6 questions, right, for re-argument, right? It's a Robert Jackson idea. It's a Felix Frankfurter idea. It's this idea of Congress being the body that is more able, right, through legislation to guide the desegregation of the nation's schools, rather than the Supreme Court, which is sort of limited in the types of remedies it can offer. And they really were ahead of their time, right? They're ahead of their time because, of course, the 1964 Civil Rights Act, provides the remedies, right, for schools to be desegregated and to prevents any school receiving federal funds from being racially segregated, right? Those are exactly the types of remedies that Congress can use in a Section 5, or at least in the 64 Civil Rights Act, was under the Commerce power. But be that as it may, right? And I think even they asked the question to John W. Davis, I don't have the exact question in front of me, was, can Congress use its Section 5 power and the necessary and proper clause? And that, to me, is like amazing, because it shows that they have a very capacious view of Congress's implied powers, right? That even though this might not fit squarely under the Commerce power, that the necessary and proper clause, as a matter of, from the founders, was known as a sweeping clause, as my colleague John McKyle says all the time. They understood that Congress had broad powers if you combine Section 5 and the necessary and proper clause to handle this problem. And this was something that Congress was capable of doing. I mean, John W. Davis gave it the back of his hand. He's like, oh, Congress can't, amend the Constitution, blah, blah, blah. Only the Supreme Court, or through Article 5 can that happen, right? But, I think Jackson and Frankfurter were really onto something there. And that was a really wise question. And it just, in writing that chapter, it was, it was like 2 cheers for Jackson and Frankfurter by bringing up Section 5 of the necessary and proper clause.
Your timing of that isn't any better, because Sunday, Federal District Court Judge Richard Gergel is going to be here, and I'll be interviewing him, like I'm doing you, about his book on Justice Waring with Briggs and Elliott.
Yeah, Wady's Waring. I know, I've read the book, and I've met Judge Gergel, actually, and you're going to have a great time. So yeah, I mean, no doubt, right? Like another judge, Wady's Waring, who's just so ahead of his time, right? And risks everything. So you're going to have fun with Judge Gergel. He's great. Tell him hi for me, please.
Well, I certainly will. The Brown versus Board is May 17th, 1954. Robert Jackson attends that session, and then he comes and attends the first Monday in October of 1954, last public session, and then he dies. How did Felix Frankfurter react to all that?
Well, I mean, the first thing we know from Barrett Prettyman, which I know is, Frankfurter informed Barrett Prettyman that, we've got a problem, right? Which is, he had a heart attack at Elsie Douglas's apartment, and that started all sorts of salacious rumors. And Frankfurter, but let's put all that aside, because Barrett's covered that. I think what my book shows, and it really doesn't get into that much, other than the fact that she was found at his apartment, and that maybe J. Edgar Hoover settling some scores leaked that detail, that he was found at his apartment, because Robert Jackson, when he was Attorney General, was opposed to wiretapping, and Hoover may have been settling scores, and Frankfurter hated Hoover with a passion, and Hoover, of course, had an FBI file on Frankfurter going back to the 1920s that I used. But I think Frankfurter was really shattered, right? And I think he was shattered on a kind of a personal level, on an intellectual level. I think he knew that there was no way he was ever going to find somebody who he felt as close to on the court, right? And who had the kind of shared history that they had, right, in the New Deal going back to 35, right, where they're fighting for the constitutionality of the Second New Deal together. They both revere Franklin Roosevelt. They both take away the same message from the New Deal constitutional crisis, which is opposing the idea of judicial supremacy, this idea the Supreme Court should have the last word on the Constitution, right? Hence their belief in Congress's Section 5 power of the 14th Amendment, right? And just kind of on an interpersonal level, the ability to argue about cases, the ability to disagree about cases, because they weren't in lockstep on cases. As we talked about Barnett, right? We could talk about Bridges versus California, right? We could talk about a lot of habeas corpus cases where Frankfurter's in favor of granting habeas corpus and Jackson is not, right? And and others, right? Jackson's, very much changed by his Nuremberg experience when it comes to, the threat of the Communist Party, right? So there are differences, but just on an intellectual level, and the amount of intellectual respect Frankfurter had for Jackson was enormous, and just their personal camaraderie that they had, the kind of ability to like give and take and really dish about people, even just to blow off. I think they both had tempers, right? And I think they both were men who liked to blow off steam. And I think what was really healthy for both of them was to blow off steam about people to each other, right? Rather than in the conference room, or rather than, to others that might make it in the newspaper. So I think that was a really healthy relationship, that they were able to blow off steam to each other. And Felix was just really, really sad. And he writes to learned hand, right? It's just not gonna, this job will never be the same for me ever again, right? He writes hand later on, like, I like John Harlan just fine, but he's no Robert Jackson, right? And what he means by that is, Robert Jackson's like John Harlan's amazing justice, right? And great, and a good friend to Felix all the way to the end of his life. But he's a kind of patrician, white shoe wash, New York lawyer, right? And he hadn't fought the wars of the New Deal like Frankfurter and Jackson did. There was no, and just Harlan's personality was less fiery than Jackson's was. There was no way Harlan was ever going to be as close to Felix as Felix was with Jackson. And I just wanted to point out one other thing, and I quote extensively from it in the book. Felix writes not one, but two tributes to Jackson in the law reviews. And he said he spent hours on them, right? Writing them. I know I criticized his opinion writing and not being diligent enough on his opinion writing, but he said these things took hours. And I just want to also point out, it wasn't just all praise for Robert Jackson either, right? He pointed out some of Jackson's flaws in those tributes. Like, what better sign of friendship is there not just to aggrandize someone, right? And just say how great they are, but to point out that, like, hey, sometimes Jackson's ability to turn a phrase, and I think he's, he and Justice Holmes, Jackson, are the two greatest phrase turners that have ever been on the court. He says, hey, that's sometimes a double-edged sword for Robert Jackson, and that Jackson knew this, that sometimes his ability to turn a phrase was kind of too clever by half, right? And like to say that after somebody's dead, like that shows how much you care about that person and love that person. And let's just like bring it full circle. He hires Jackson's most trusted law clerk, E. Barrett Prettyman, to stay on with his chambers. And then he hires Elsie Douglas because he knows that she's brilliant and that there's no better administrative assistant slash nerve center, right? At the Supreme Court of the United States than Elsie Douglas, right? But she needs a job, right? Like on like a, he basically imports the best of Jackson's chambers into his own. And like what better tribute to Jackson is there, than doing that and then keeping Jackson's memory alive. And one thing that was interesting to me also, Greg, is that you can tell how much I love Justice Jackson, right, and just admire him a ton. That Frankfurt didn't see Jackson's memorandum. I think John and I are pretty sure on this until after Jackson died, right? He knew about its existence, possibly from Barrett, but had never seen the memorandum about Brown until later when Elsie dutifully notes in her files when Frankfurter takes a look at the memorandum. It was just a beautiful friendship, and I just think Frankfurter was a little bit adrift. I wonder if Frankfurter's, you always wonder like counterfactually what would have happened had Jackson lived, right? I wonder if Frankfurter's relationship with Warren wouldn't have deteriorated, quite as quickly as it did, because maybe Jackson, because he was such a longtime friend of Warren's, could have been kind of a barrier, an intermediary between them, or maybe even a translator between them, and that Jackson could have helped Frankfurter navigate that relationship a little better because, sadly, it didn't take long after Brown versus Board of Education, really in the Red Monday cases in 1957, when Frankfurter's relationship with Warren really goes downhill fast. And I just think Frankfurter would have been happier. I think he would have written better opinions. I just think there were a lot of times where Jackson's wrote stuff that caused Frankfurter to do a double take, right? I admire Jackson's Korematsu dissent tremendously. And Frankfurter rewrote his concurrence after Jackson circulated his Korematsu dissent and said some things that I thought needed to be said. Even though I think Frankfurter got that case totally wrong and shouldn't have been sitting on it in the first place because he was too close to Stimson in the War Department and advising on policy. But, I think Jackson made Frankfurter a better justice. And I think without him on the court, that Frankfurter was not quite the justice that he had been when Jackson was on the court. And on a personal level, he just lost a friend, right? I remember he says, like, now I'm going to sit next to Harold Burton, and Frankfurter loved Harold Burton and thought he was the fairest of all of them, much like Barrett Prettyman did. But he said it won't be any fun, right? Like, he misses that kind of give and take with Jackson sitting next to him on the bench. So I just think a little light went out in Frankfurter's professional life when Robert Jackson died, and I hope I conveyed that in the book. It's one thing I really tried to do. I had to stop myself a couple times and say, hey, this isn't a book about Robert Jackson. This is a book about Felix Frankfurter, because my admiration for Robert Jackson's so deep, as a writer, that I had to stop myself a couple times and say, the Rehnquist Jackson stuff doesn't have to go in here. I took it out, right? I'm like, this is not a book about William Rehnquist and Robert Jackson. This is a book about Felix Frankfurter, and I had to pare it back, but I did it all out of love.
This is unbelievable. I'm going to wear you out because we have some time. We got to go on tomorrow. So I'm going to stop this now and say thank you. You're amazing, and I could listen to you for hours, and hopefully I can get a kind of an hour worth of legal credit because of this conversation.
Well, I hope you get your CLE credit out of this too. But you ask all these great questions. You have like layers and layers and layers of knowledge about Robert Jackson in each question. It's so easy and I just wanted to kind of contribute these videos are kind of a high bar, Greg, and everybody offers something and they're really for history, right? You've done a great job doing these, right? Like I could access, interviews with Frank Sander and William T. Coleman and all these people that you've interviewed along the way. They're really for historians. And so I just wanted to add and leave some breadcrumbs for future historians to really pick up some threads because, this isn't the last time people are going to write about Felix Frankfurter, Robert Jackson, and Brown versus Board of Education.
Well, fantastic. Thank you. Be well. We'll talk tomorrow.